Hi, this is the business guy with Asset Protection Planners, and in this video we're going to talk about community property states versus common law states. And the reason this matters to you is because if you live in the United States, you live in one of these two types of states. And where you live can affect you in a big way when it comes to protecting your assets from lawsuits, the assets of your family, as well as what happens when a divorce occurs and what happens to your tax bill when one spouse dies. And of course, if you appreciate all this information being condensed down to just the facts, it really does help me out in a big way when you hit the like button so YouTube promotes this video. And if you're brand new here, feel free to hit the subscribe button and notification bell. It's totally free to do, and that way when I post a new video like this one, you'll be up to date right away. Thank you so much, and now back to our topic. In community property states such as California, where I lived for 20 years, the assets of each spouse are considered assets of the marital unit. The assets of each partner in their relationship are not legally separate from that of the spouse. That is, when a couple is married, creditors of one spouse with certain restrictions can seize the assets of both spouses. In non-community property states, on the other hand, the assets of the debtor spouse, that is the one who lost the lawsuit and now has a judgment against himself or herself, are separate from the other spouse unless both spouses are indebted to the same creditor. Now, the community property concept is a remnant of Spanish law. Community property law is a form of property ownership which dates back to the year 693 in Visigothic Spain. It assumes that spouses contribute equally to their marriage. It disregards their individual income or earnings. Thus, each spouse gets an equal division of marital assets in the event of death or divorce. In states that apply this system, the property acquired by the married couple during their marriage is joint property. This is even the case if one spouse acquired the asset during the marriage solely in his or her name. In addition, community property can become an issue of contention during divorce proceedings and following the death of a spouse. Like the 69-year-old man who died and wanted to legally change his age because his real age was affecting his job prospects as well as his chances of success on Tinder, a popular dating app. The judge denied his request and the girls on Tinder can breathe a sigh of relief. But I digress. In contrast to community property states, in tenancy by the entirety state, such as Florida, where I live now, married couples have the option of owning an undivided interest in property. Thus, it essentially creates a third legal person separate from the individuals. So holding assets in this fashion theoretically protects them from judgments against one individual spouse. Now, community property states include the following states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, as well as the U.S. territory of Puerto Rico. Though it includes only 9 out of the 50 U.S. states and 1 U.S. territory, 25% of the U.S. population lives in community property states. And this is mainly due to the inclusion of the 2 most populous states, California and Texas. The state of Alaska allows couples to choose whether they would like to follow community property or common law when dividing their marital assets upon death or divorce. Now, it's important to know that community property law also applies to a couple's domicile, which may or may not be where the couple lives. A domicile is a person's legal permanent address. For couples who do have homes in multiple states, or who frequently move, or who are in the military, establishing a proper domicile is important in order to determine how they'll divide assets in the event of divorce. Legal analysts use the following criterion to establish a person's domicile: whether a person is attending school, in the military, or on a temporary work assignment, the location of a person's residence, where the person's family is located, where a person registers his or her vehicles, the place a person registers to vote, where a person files his or her state income taxes, and other indicators which describe a person's ties to a community. Now, the states generally define community property as those assets which meet the following requirements: property which a person or their spouse acquires separately or together during marriage, the property that a couple agree to convert to community property, or property that one cannot identify as separate property. Now, speaking of identify, some men now say they identify as women and some women as men. Me, I identify as a cat who plays basketball, and I prefer to be referred to as Caddyshack. Now, what is separate property? In community property states, property is typically defined as separate under the following conditions: property that a person or their spouse acquired prior to marriage, that property which a person or their spouse received individually as a gift, inheritance, or life insurance policy paid out to an individual during marriage, money earned while living in a state where community property law does not apply, property which was bought separately with separate funds or exchanged for separate property. Now, notably, in Texas and Idaho, income derived from separate property during marriage is considered to be community property, whereas all other community property states, it's considered separate property. Now, if you don't get married, you don't have community property. Therefore, with the exception of Texas, it is only through formal marriage that common property law applies. It is not relevant to couples who have entered into a common law marriage. However, some property rights may be derived from long-term cohabitation, and this is to make sure that division of assets between cohabitants is equitable. This is particularly the case in situations where the cohabitation resembles those of traditional marriages. For example, one party leaves for work each day and the other stays home raising the couple's children. Protecting assets in a community property states. Option number 1, trusts. Now, there are a few good ways to protect community property assets. The best, an offshore trust. Where? The Cook Islands or Nevis. In these two jurisdictions, they have the strongest asset protection trust statutes. With these trusts, you have an international trustee. In our case, our trustee is our offshore law firm. So the trustee is not subject to your local court orders. Now keep in mind, a local judge only has jurisdiction over local affairs. Conversely, affairs of foreigners are subject to the laws of their own jurisdictions. Now fortunately for you, if you're a judgment debtor, in certain jurisdictions the laws are tilted steeply in your favor. As a result of these great international trust laws, this stacks the deck against your opponent at law. Furthermore, there is extensive information on our YouTube channel about planning your wealth preservation strategy using an offshore asset protection trust. Or you can speak with one of our on-staff attorneys or consultants by calling the number below or filling out a free consultation form on our website. For couples who stay married, the community property system can present some limited advantages and tax benefits. The following are two instances where this system can provide advantages. Number 1, the step-up rule. The community property system can impose tax consequences in the event of divorce. However, it can offer some substantial benefits for couples who own real estate and stay married in the event of the first spouse. In community property states, the code can step up the tax basis of such property to fair market value. For example, let's say a married couple bought a house for $100,000. Then it was worth $1 million when one spouse dies. The surviving spouse can sell it and only pay taxes on the amount of profit above the $1 million mark. Non-community property states only step up half the value. This can result in a major income tax advantage with regards to depreciated real estate when the surviving spouse wants to sell. Community property and bankruptcy. Now, in community property states, all community property that exists at the time that one spouse files for Chapter 7 bankruptcy is included in the bankruptcy estate. That's right, all from both spouses. This includes property acquired during the marriage. In fact, it even applies to the property which the spouse who did not file for bankruptcy holds individually. In the state of California, for example, premarital creditors of either spouse have the ability to make claims against community property, so they can collect payment for debts incurred by either spouse. Premarital tax liability is included in this claim. In fact, I was in a courthouse one day and I decided to walk into the bankruptcy court in session in the community property state of Nevada. The husband of a husband-wife couple tried to file for bankruptcy, but the judge would not accept the bankruptcy unless the other spouse filed bankruptcy too. So in community property states, both spouses usually must agree to file for bankruptcy. So doing so messes up the credit of both spouses instead of just one. Now, in most Chapter 7 bankruptcies, the debtor does not have any non-exempt assets, but is still able to obtain a community property discharge. Once the court grants a discharge through bankruptcy, the creditor with a community property claim cannot pursue community property for a payment of debt. In an unusual case where one spouse is allowed to file for bankruptcy, it also stands true if that property is held solely by the spouse who does not file for bankruptcy. This discharge also protects community property acquired by either spouse after one spouse files for bankruptcy. Now, how do you opt out of the community property system? Now, there are a number of reasons why couples may find that the community property system is not beneficial for them. They may wish to maintain their autonomy during marriage. For example, they may find that combining their assets is disadvantageous for tax purposes. In addition, they may simply want to avoid the difficulty of dividing assets in the event of divorce. If desired, the couples whose domiciles are in these states can utilize the following methods to opt out of the community property system. Number 1, don't marry. When a newly married man looks happy, we know why. But when a 10-year married man looks happy, we wonder why. Too late for me. I've been married for 32 years, and I'm in it for the long haul. The secret? I was lucky. I didn't marry a human. I married an angel. She's a real sweetheart. Now, in most, but not all instances, if a couple is not married, the court will not view the couple's individually owned assets as community property. For financial plan information on how common law affects community property, keep watching. Number 2, premarital, postmarital, or divorce agreement. A couple can choose to draft an agreement which converts community property into separate property in the event of death or dissolution of marriage. The benefits of such an agreement is that the assets then become subject only to the claims of the creditors of the individual who holds the assets. All community property states give the option of opting out of the system. That is, given the provision of a formal written premarital agreement according to the Uniform Premarital Agreement Act. Now, in some states, it is possible to opt out of the common property system without a formal premarital agreement. However, other states, such as California, have stringent transmutation requirements. That is, the statutes assert that without an explicit formal written agreement, community property law applies. It's likely that other community property law states will follow California's lead. Thus, it is plausible that other states will adopt stricter requirements for opting out of the community property system. As such, it is advisable to draft such an agreement in jurisdictions where they do not currently deem a formal agreement necessary. And number 3, the Innocent Spouses Act. Now, the Innocent Spouses Act is a provision of U.S. tax law, that is, income earned or assets their partner held that their partner did not disclose to them, especially upon death or divorce. The legislature therefore designed it to protect a spouse from tax liability that they are unaware of. So the bottom line is, whether you live in a community property state or a common law state, there are ways to protect yourself from lawsuits. You can call one of our attorneys or consultants to find out which strategy best meets your needs wherever you live. So go ahead and call us at the number below or fill out a free consultation form on our website. Please click like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy.